When should you file your trademark application? I'm Mike Steger. I'm a trademark and copyright attorney, and I'm going to tell you right now. So in a lot of other videos I've done, we talked about what kind of trademark you should file, what goods and services you would need to cover, and various complications in what can or cannot be registered. But one of the considerations for filing for a trademark application is when you should file. So we've talked before, there's two basic kinds of grounds for filing a trademark. One is use in commerce. That's you're already using the trademark with your business. That one you should file whenever you can, as soon as you can. The second basis for filing is an intent to use, and that's you have found a trademark, you want to use it, you're not using it yet, but you can file now and go ahead and try to reserve that trademark. Eventually, you will have to prove use by showing that you are using the trademark in connection with your goods or services. But when should you file that application? As the answer, as with many of my videos, is it depends. If you have a business plan and you've come up with a trademark that you think is great and is going to give you some value with your business, you want to file as soon as you can, with the caveat of when you would have to prove use. So the trademark office right now is really backed up. It's taking generally at least 10 months for an examining attorney to review your application. Once the application for an intent to use trademark is reviewed, it has to go out for what's called publication. Other people have a chance to oppose your application. That's generally going to take a couple more months, 4 or 5 months after the 10 months to review it. Once the application is then approved, you'll get what's called a notice of allowance, and you have 6 months after that to prove use. If you can't prove use in the 6 months, you can request for a fee an additional 6 months to prove use, and you can get up to 5 extensions. So essentially, from when you get your first notice of allowance, you have 3 years to prove use. So you want to make sure you're going to be able to prove use within that period. If you can't, then your application is abandoned and you have to start again from scratch. So that's some timing considerations to keep in mind when you're planning your trademark strategy and when you should file an intent to use trademark application. I'm Mike Steger. I'm a trademark copyright attorney. If you have any questions about your trademarks or copyrights, give me a call.